Hello guys, welcome back to my YouTube channel. My name is Serena WW. I am a YouTuber based in Nigeria. My content is about productivity, lifestyle and law, and in today's video we are going to be doing the City Lawyer series, and today we are going to be doing copyright, patent, trademark. So let's jump in. So if you're a new subscriber, welcome. If you're an old subscriber, thank you so much for coming back. I'm so excited to have you. Please don't forget to like this video, comment down below and subscribe. Thank you so much. So now let's get into today's video. First of all, what is copyright? So a lot of people have their work on the internet, a lot of people have their books written and all of that, and there needs to be laws to protect the usage of this the service they provide, and so that people don't abuse it and start making profit of it. As a result of that, there is a law that governs literary work, artistic works and the likes. So first of all, what does copyright mean? Copyright means the rights that a person have over the physical work, the right that the person have over his physical work, the right to copy, that means the right that the owner of the work has to make copies of the work, and a work must be copied right. That is, it must be copied right. So now let's go straight into the eligible subject matters that should be copied. So what are those eligible subject matters that can be copied under copyright? First things first, the subject matters that can be copied under section 1 sub 1 of the Copyright Act is literary work, musical work, artistic work, cinematographic films, sound recording and broadcast. So this literary work has to do with novels, stories, poetic work, choreographic work, computer program, textbooks, etc. All this can be under literary work, which is subject to copyright protection, which can be found in section 51 sub 1 of the Copyright Act. So what other work can also be under copyright protection? We have musical works. This can be protected as well. We have artistic work, all under section 51 of the Copyright Act. Under artistic work, we have map, plans, diagram, work of sculptures, photography, works of architecture, work of artistic craft and paintings. So all this can be under copyright protection. So under the cinematographic work, this has to do with like filmmaking and the likes, and sound recording. Those two can be protected. So on broadcast as well. So but then there are substantive requirements for you to be able to be protected under copyright, which has to do with originality. That means it has to be a work. First of all, it has to be a work within the definition of the Copyright Act. So first of all, what are the substantive requirements for copyright protection? First of all, there must be originality. It has to be a work. It must be a work that is stated under the Act, and it must fall within the context of what originality for it to be protected under copyright laws. So now let's go into the next substantive requirements for copyright protection, which is fixation. So now when we talk about fixation, this is under section 1 sub 2b of the Copyright Act. Says that the work has to be fixed in any medium and by any agencies that will further process it. So for it to be under copyright protection, there must be what? An element of fixation. Another thing, so the idea expressed must be one that is within the copyright protection. And the next point to note is that when can you say that a copyright work has been infringed upon? According to section 1 sub 4 of the Copyright Act, a work is not eligible for copyright only for so first of all, now let's go into copyright registration. Your copyright work must be what? So like I was saying earlier, your copyright work must be what? Registered. Your copyright work must be registered. However, there is something we call limitation of time, duration of time. So different type of work have like the duration of registration of thing called duration of copyright. So you must consider the duration of each of your copyright work after registration. So first of all, the first schedule of the Copyright Act actually provides for date of expiration of each copyright. So each copyright actually expires. So the copyright does not last. The copyright registration protection law does not last for eternity. you will need to renew it. So for literary work, musical work, and artistic work, and any other work under photography for copyright is 70 years after the end of the year in which the author dies, and in the case of a corporate body or a government agency is 70 years after the end of the year which it was published. Cinematography, films, and photography, 50 years after the end of the year in which the work was first published. Sound recording, 50 years after the year in which it was recorded. Broadcast, 50 years after the year in which it first took place. After this period, that means you can no longer enjoy copyright. However, there's even room for joint authorship, and this is a situation where two or more persons actually own a particular copyright. So now let's get into ownership and transfer. They say copyright can be assigned, it can be given as a testamentary deposition or by operation of law under section 11 of the Copyright Act. So this is a situation of a contractual agreement which exists between two parties to be able to give own copyright and transfer copyright transfer copyright to another individual that is interested. So now let's get into the next angle of intellectual property protection. Trademark and patent. First of all, we'll talk about trademark. Now, what is trademark? So according to section 67 of the Trademark Act, a trademark means, except in relation to a certification trademark, a mark used or proposed to be used in relation to goods for the purpose of indicating or so as to indicate a connection in the course of the trade between the goods and some other persons having the right, either as proprietors or as registered users, to use the mark, whether with or without any indication of identity and means in relation to certification trademark, a mark registered or deemed to have been registered under section 43 of the Trademark Act. So basically, in this context of trademark must be used in relation to business. So for instance, now if someone is being called Odogu and Odogu is not used in relation to business, you cannot say that is your trademark, except in some other countries like America. You can register that name as a trademark because, for instance, maybe you're a musician and they refer to you as Odogu and you want to use it to represent your brand, and obviously your business, your music is your brand which you are making money with. Fine and good, you can register that under the trademark law. However, you must verify whether that is registrable. So, but although we'll get into what is registrable and what is not, so you can use that in relation to your business. For instance, now if you are using Odogu in terms of, let's say you are producing service or producing products, Odogu name can be your trademark, and some of these things are actually contestable in court. So that's why you must verify whether these names actually fall within, or this name, logo, symbols fall within the trademark within the ambit of the law as regards trademark. So now this use in the course of business is relevant for, like, for instance, for trademark to be trademark, it must be used or proposed to be used in course of what? Trade. Now, first of all, what are those marks that are actually registrable? What are those marks that you can say, okay, these marks are actually deemed as trademarks? So under the Nigerian law, we have Part A and Part B. So I'll discuss Part A. So Part A actually talks about the fact that a trademark other than a certification trademark may be used under Part A of the register, that is section 9 sub 1 of the Trademark Act, where it says that this trademark is the name of a company, individual or firm represented in a specific or particular manner, the signature of the applicant for registration or some predecessors, an invented word or words, a word or words having no direct reference to the character or the quality of goods and not being accorded to the original significance, a geographical name or a surname, or a distinctive mark. So under Part A of registration, those are provided for under section 9 sub 1 of the Trademark Act. You can see that these are deemed to be registrable trademark. So if it does not fall within this ambit, sorry, you lost your opportunity for that mark to be what registered. Now let's go to the Part B of registration. So in order to register a trademark under Part B, it must be capable of being used in relation to business or proposed to be used in relation to business or distinguishing goods which the owner of the trademark may use in case of what goods. Now let's go to marks that are not registrable. So there are certain marks that you cannot register. Now let's go into this marks. So first of all, the marks that you cannot register, deceptive and scandalous trademarks are unlawful. The law says no, it is unlawful. For instance, trademarks that are contrary to public policy, morality, and a scandalous design, the law says no. Then also, when you have trademarks that are identical or resembling trademark, for instance, let's say you have Dudu Osun or Dudu Oshun, and they are similar, it won't fly as a trademark, it will not be registered. Then also, if we have trademarks that relates to name of chemical substance, it will not be registered. For instance, now let's say you mix your trademark with something like H2O, which represents water, is a chemical substance, it will not fly as a trademark. Then associated trademark, certification trademark, defensive trademark, separate trademark, resembling trademark, those cannot fly as trademarks. So now let's get into the next ambit, the types of persons that can actually own a trademark. So people that can actually own a trademark means anybody can own a trademark. Any person claiming to be a proprietor of a trademark can apply for. So let's get into the category of persons that can apply for trademark. First of all, if you are claiming to own a trade and you want to register your business logo or symbol, you can fly for registration of trademark. So you are fit and proper for registration of a trademark. A joint owner of a trademark can decide to register it. A corporate body not yet formed can decide to register its trademark. A registered user can decide to register its trademark. And your procedure for registration of your trademark is duly provided for in section 35, section 34, sub 1 of the Trademark provided for. So the procedure Trademark Act. So you can do your research and find more about that. Now let's talk about the rights and the limitation of a registered user for trademark. First of all, the rights are duly provided for in section 34, sub 7, section 33, sub 5, sub 3, and sub 4. And when you read through this Trademark Act, you will know your rights that are available to you. But let me just give you a sneak peek, because obviously, first of all, your rights is that as a trademark user, you are permitted to use it in relation to business, and not to use, and this trademark must not be used by any other person than the proprietor. So first of all, your rights as a registered user of a trademark is one, that you can use it as a registered user, and any other, the limitation there is no other person that is not a proprietor to that trademark can use the trademark. You get? I hope you get. So now let's talk about the duration, and also it must be noted that trademark can actually be assigned. So you can assign your trademark to someone else under Trademark Act. However, there is a duration for your trademark and renewal of trademark. So registration of a trademark actually takes a period of 7 years. After that, it can be renewed from time to time for a period of 14 years. So basically that is it. And the procedure for registration is, for instance, application for registration, preliminary advice on distinctiveness. First of all, you must ensure that this mark that you want to register as your business mark is distinctive. Distinctiveness in the sense that, you know, when I talked about copyright, I mentioned something of originality. Distinctiveness in which means that no other person is using your mark. It is distinguished, like nobody else in the world has that mark. For instance, if we see that apple that is half beaten, you understand, you know it's an Apple company. So no one in the world uses Apple company logo. For instance, if we see Celebration Church, we know that Celebration Church is their logo. Do you understand? When we see Reading Church, or let's say when we see Forbes, when we see Benz, we know that okay, this is their distinctive logo. So you must seek advice whether your mark, first of all, is permissible under Part A or Part B, and if it's distinctive, if it's distinguished and is capable of standing on its own, then you now apply for it after you have sought rights, after you have sought the necessary that part out. So publication of notice, after you have done the distinctive check, you will do application for registration. Then you will now move to publication of your notice. Do your publication of notice. Then if there's any objection to your registration, it will be stated. Then you can appeal to the registrar of the decision. For instance, now if your there's an opposition to your registration, maybe someone else has that trademark, you can actually appeal the decision and all of that for against the registration. So you can appeal from the registrar's decision on or post application. Then you now register again. After that, you go through that whole process. When you go through that whole process, you can finally use the trademark very well. So I guess that is all we have for trademark. What are the rights contained for trademark users? You can find that in section 7 and 8 of the Trademark Act. Then what are the exceptions for exclusive right to use the Trademark Act? You can find that in section 5 of the Trademark Act. So do very well to do your research, and you'll find more as regards trademark. I hope we must take note that the remedies available for when infringement has happened to a trademark owner is injunction, and the several different types of injunction also accounts for property, just the same remedies that I give in the copyright. So if you patents, first of all, what is patent all about? So patents are, like, for instance, laws. Patents are laws basically that protect you're an inventor and you made let's say a time machine and all of that. For you to be able to enjoy protection and avoid abuse of your time machine, you must actually register your invention for patent. So under the Nigerian law, patentable invention are invention in respect of which the law will grant a patent. So if you have any invention, the law will have to grant a patent for it to be protected. And according to the law, there are different types of invention which would be given patents over, and then there are some conditions that you must fulfill. Now, what is an invention under the category of inventions? So not everything will thrive as an invention, you understand? So there are some things that will not fly as an invention. So we must know what are those inventions that will not fly as an invention. First thing first, under the Nigerian law, there is actually no definition for invention. However, there have been statutory authorities to cite that this is an invention. So now, invention to be an invention under the Nigerian law, there's no precise definition, but there must be the presence of novelty. Novelty in the sense that it is new, it is original, like it's just a bit of copyright, but then more like patent is more strict and more stringent than copyright, because patent officials want to see that this invention was original, this invention is new, this invention has not been seen. Do you understand? So you must be able to actually prove to a large extent that this invention is actually an original new invention for it to be granted a patent. And what will an invention be to patentable? First of all, it will be new, it must have inventive activities, and it must be capable of industrial application. Also, if it constitutes an improvement upon a patent invention and is also new and results from inventive activities and is capable of an application, so like there's an emphasis to it. And this, when a patent is deemed to be patent, says that the patent is new, it results from an inventive and is capable of application. So this is actually provided for under section 1 sub 1 of the Patent and Designs Act. So now let's go into the next thing, which is very relevant to us. That is, what is non-patentable invention. So there are some inventions that are not patentable and the law will not grant patent to these inventions, and this is provided for in section 1 sub 4 A to B of the Patent and Designs Act, which provides that plants, animals, inventions that have been exploited, the inventions that are created that will obstruct moral justice contrary to public policy, will not be granted patents. Then first of all, there's the provision of the law that provides for the grant of patent. Patent can only be granted to certain category of persons. First of all, patent can be granted to statutory inventors. Patent can be granted to persons who are employed or commissioned to make inventions. Patent can be granted to people who have been assigned to make inventions, who are given a license. Patent can be granted to people who have a contractor license. You understand? And the duration for patent is that it expires at the end of 20 years from the time of the what invention, and you can reapply annually. That means it is renewable annually. So now the procedure for applying for a patent: first of all, you must lay a request for a patent with your full name and address, a specification, that means including a claim or claims in duplicate, your plans and drawing of the patent, a declaration according to section 3 of the Patent Act, a signed power of attorney or authorization if the application is made by an agent, then also the address for service in Nigeria, the prescribed fee, and also the prescribed form from the time by the registrar, a prescribed form by the registrar. So that's all there is to know as regards registration of patents. And you know, the Nigerian law, what it provides for, how it's going to be scrutinized and the like. So we should just take note of this. So if you want to know more about patent laws, leave it in the comment section below. And like I earlier told you, the remedies for patents, the remedies for trademark, the remedies for copyright are similar. So now I don't want to overflog it. So what are the remedies? We know we will get damages, we know we get an injunction, we know we get account for profit, just the way it is in the other two I have mentioned. We know we get delivery of and the like. So that is all there is to know as regarding patents. So thank you so much for watching this video. Till I see you next time. Don't forget to like this video, comment down below, and subscribe. I do what I do because of you. Hope you learned one or two for this video. See you next time. I remain Serena. Bye.